welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Peter Roscher, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Welcome to another episode of Arbitral Insight. I'm Clément Fouchard, partner in Reed Smith's Paris office in energy and natural resources. And today I'm very pleased to welcome Pacôme Ziegler. Hello, Pacôme.
Hi, Clément. Thanks very much for having me today.
Well, my pleasure. Pacôme, you are a French and Portuguese qualified lawyer. You are founding partner of De La Loa, an arbitration boutique based in Lisbon, with a particular focus on Portuguese-speaking countries. And prior to founding De La Loa, you worked at Decat in Paris and at PLMG Advocados in Lisbon. So today we will be discussing international arbitration and Portuguese-speaking Africa. And before we kick off, it's probably useful to start with a rundown of Portuguese-speaking countries in Africa. So we'll start by mentioning Angola, Cabo Verde, Mozambique, Guinea-Bissau, Sao Tome and Principe. So that we have the scene set. Pacôme, my first question for you. Your practice focuses on Portuguese-speaking countries, and I understand that you are particularly active in Portuguese-speaking Africa countries. Any recent interesting developments regarding international arbitration in these parts of the world?
Well, yes, there indeed are interesting developments there. And if I may, I will start with Angola. Angola has been facing a severe economic downturn recently over the last couple of years. And in this context, the government has been keen to try and attract more foreign direct investment. And as part of this drive, they've been making recently quite a few changes to their legislation just to try and create a more favorable environment for FDI in Angola. So, for instance, they've enacted a new foreign investment law in April 2021. They've made changes to foreign exchange regulations, aiming essentially at cutting red tape or at least outsource the approval of foreign invisible transactions to commercial banks, something which previously was done by the central bank itself. So it was very, very cumbersome. And all that occurred between August 2020 and December 2021. So that's very recent. On the arbitration front, there's also been a push towards making Angola more arbitration friendly, I would say. Angola has ratified, for instance, its investment treaty with Portugal, which it signed in 2008. So they ratified that in 2020, so 12 years after signing it. And of course, last but not least, on 1st September 2021, the Angolan parliament has approved Angola's accession to the ICSID convention. So I would expect Angola to soon depose its instrument of ratification or acceptance, and thereafter becoming then a member state of the ICSID convention.
Okay, and then do you expect the entry into force of the ICSID convention vis-à-vis Angola to imply a sort of a boom in investment arbitration against the state or involving Angolan nationals?
Well, I mean, the ratification of the ICSID convention they're certainly sending a signal there to the market in general and to foreign investors in particular to the effect that they're open for business, so to say. But still, I think the impact of that is likely to be limited, at least in the short to medium term. There's a couple of reasons for that. First, the trend in inbound foreign direct investment in Angola is unfortunately negative. It's a divestment trend. The balance of inbound FDI is indeed negative since 2016, which means that foreign investors are basically divesting, especially in the oil sector. So, in this context, I'm not sure there will be an increasing number of actions initiated against the state. But it may soon change because, as we know, oil prices are going higher, and the Angolan economy is highly dependent on oil revenues. They represent 80% of the national GDP and 90% of foreign direct investment inflows in 2021. So let's see, what happens there. The second, I think, reason why I don't think we're going to see any boom in arbitration in Angola or involving Angolan national is because Angola has only a limited number of BITs in force. They have 6 to be precise. One with Germany, Italy, Russia, Portugal, Brazil, and Cabo Verde. And none of these countries is a major source of foreign direct investment. There was no inbound foreign direct investment from Russia or Cabo Verde over the last few years. And the FDI stock from Brazil and Italy is also quite insignificant. I mean, there are some flows coming from Germany and Portugal, but nothing very significant either, at least according to the national statistics from the investment agency. On the upside of that is all of these BITs, which are currently in force in Angola, do provide for ICSID as a venue for investment arbitration, except for the Brazil-Angola BIT, which actually does not provide for investment arbitration at all, and instead refers investment disputes to local courts. On a side note, this is kind of unsurprising, as we know that Brazil's general stance towards IDS is pretty much against ISDS in general. So, based on these currently enforced BITs, it's unlikely that they are going to generate a significant number of ICSID arbitrations just because there aren't enough of them. Another factor yet is future BITs. And there, what's interesting is Angola has actually a model BIT, which it prepared in 2014. And amongst many oddities of that BIT model, or an orthodox BIT, I would say, well, it provides that investment dispute between investors and states must be settled before local courts. And I understand this model BIT was actually the basis for the discussions between Brazil and Angola. And as I just told you, well, this BIT doesn't have an investor-state arbitration clause. So let's see here again how things evolve if Angola is going to draft a new model BIT, which would actually contain an investor-state dispute resolution clause. Last, the lack of BITs could be remedied by the national Angolan investment law, and there is a national investment law which, as I said, was enacted in 2021, and this law does allow for arbitration, but it does not specify the venue. There's another law which is relevant here, which is the law governing petroleum activities, which is key, as I said, because 90% of FDI is coming from the oil sector. And this law provides for arbitration, but it's arbitration seated in Angola, subject to Angolan law and conducted in Portuguese. And the way this law is drafted, actually, it suggests that the clause is mandatory d'ordre public. So you cannot basically contract out of it. So, in conclusion, this would have to change in order for Angola's accession to ICSID to translate into more ICSID arbitrations involving Angola or Angolan nationals.
Thank you. And so you mentioned this remedy before, under local arbitration law, when you have, for instance, a dispute arising out of petroleum activities conducted in Angola. How does it work? Can you say a few comments on that?
Yes, of course. I have personal experience arbitrating under the Angolan arbitration law, and I can tell you firsthand that it's tricky. It's tricky. The law is based on the ancestral model law, but in reality, it significantly departs from it. There's, particularly one very, I would say, dangerous provision, which is that the tribunal is bound to reach a decision within 6 months of its constitution. And there's a possibility to extend that deadline, but in order for that deadline to be extended, you need the agreement of all parties. So obviously, if one of the parties does not want to participate in the arbitration, then it can just easily sabotage it by refusing to consent to an extension. So that's a big issue, and one of the reasons why, when I am asked by investors if they have a clause providing for arbitration under Angolan arbitration law. If they can go there, the answer is usually no, don't go there. And there's also another issue which is not based, which does not derive from the arbitration law, but from the law governing advocacy. So what lawyers can do in Angola, and as is somehow frequent in some countries, is foreign lawyers. I mean, it's a crime for foreign lawyers to represent clients in Angola, and there's no carve out for arbitration proceedings. So anytime you have an arbitration seat in Angola, or even so when the hearing or any hearing has to be held in Angola, then being a foreign lawyer, it's extremely worrisome, and I have actually been threatened with criminal proceedings because I was representing a client in a Rwanda seated arbitration. So that's tricky.
Wow, indeed. I mean, these two points alone are telling. I mean, I find it quite interesting to note that the law you're just referring to dated only from 2011, which is not that old, but clearly it's not in line with the international sort of standards we see. Do you know if there's any plan to revise the law?
Yes, I mean, back in 2015, there was the Ministry of Justice, the Angolan Ministry of Justice, created a working group and tasked it with, asked it to come up with proposals to revise that law. Because I think they knew there were shortcomings there, and there was, they hadn't seen any significant increase in arbitration in Angola. And so they did set up this working group, which came up with a string of recommendations shortly thereafter, still in 2015. So that's already 7 years ago. And I mean, these recommendations are more or less useful because they did identify the issue with the timeline for rendering the award. But what they suggest is to only extend, this 6-month deadline for the tribunal to render its award. But they did not seem to identify the issue of this requirement that all parties consent to extending the deadline in order for that extension to be possible. So, I wouldn't say it's headed in the right direction, at least based on this report. But in any case, these recommendations, to date, and as far as I know, they haven't been acted upon yet. So we're still where we were in 2011 when that law was enacted.
Thank you, Pacom. So we have discussed a few recent developments in Angola. Any other developments in the region?
Yes. I mean, as you know, there's a massive liquefied natural gas project going on in northern Mozambique in the Romuva basin. So if you don't mind, we could talk about that. So maybe I can give you a little bit of background there. So back in 2006, the government signed 2 exploration and production concessions for 2 offshore blocks located in the Romuva basin in northern Mozambique. These 2 blocks, just to put things into context, are right next to one another. There's 2 areas, Area 1 and Area 4, and Area 1 is closer to the shore. Area 4 is a bit farther offshore. But these blocks, in any case, are very far to the north of Maputo. It's about 1,000 miles to the north. It's right next to the border with Tanzania. After 3 years of exploration, they found a vast quantity of natural gas there, both in Area 1 and Area 4. Estimates of the quantity of gas there are said to be in the region of 100 trillion cubic feet of proved natural gas and even more natural gas resources. So if these resources are all put into commercial production, Mozambique could soon become the world's 4th largest natural gas producer and exporter on the planet. So it's a very, very significant find.
Oh, I see. Thank you. And then who holds the concessions and what are the plans?
So as I told you, there are 2 areas in this basin. Area 1, the concession there is held by a consortium currently led by Total Energies, also a French company who's also acting as primary operator. Total Energies bought this asset from Occidental in May 2019. And right after Occidental actually acquired the asset from Anadarko. So it was kind of a complex deal, which made the headlines at the time. The area for concession is held by the Mozambique Remover Venture. It's a joint venture of ExxonMobil, Eni, and China National Petroleum Corporation. ExxonMobil is poised to lead the construction and operation of onshore facilities and related liquefaction plants, whilst Eni will lead upstream developments and operations. What are the plans? Well, in both areas, both operators are planning on constructing huge onshore liquefaction plants and related facilities. Total Energies project is set to represent an investment of 20 billion USD. The final investment decision was reached in June 2019, so soon after they actually acquired the asset, and construction started soon after. And at the time when they started construction, the expected timeline for completion was, and actually for the gas to come, for the plants to come into production, was 2024. It's currently the largest ongoing private investment in Africa. Just so we have an idea of how big this is. ExxonMobil's plan, in turn, also include the construction of 2 liquefaction trains or plants and all related facilities, a jetty, an airstrip. It's massive, and the investment is said to be in the region of 30 billion USD. There, however, in contrast to Total Energies plans, no investment decision has been reached yet, at least as far as I know, based on press reports. And I also understand from press report that this final investment decision by ExxonMobil has been postponed several times. That's where we are, as I understand from press reports.
And do we know why ExxonMobil has been postponing its investment decision?
Well, I will base myself here on press reports because I have I'm not privy to this project. And according to press reports, there could be a conjunction of factors behind this decision by ExxonMobil and its consortium. So the pandemic, the COVID-19 pandemic is one of these reasons, but the press also reports pressure from shareholders for ExxonMobil to reduce its carbon footprint. In a Reuters article published on 4 November 2021, Liam Malone, who's ExxonMobil's president of upstream oil and gas, he said that he wanted to reduce costs, to green its investment by capturing carbon dioxide. And what Liam Malone also says in that article is that one of the things that are holding them back is the jihadist insurgency that is ravaging the concession areas since 2017.
And this insurgency, jihadist insurgency that has been reported in the press, I guess that also impact Total Energies' plan, right?
Yes, of course. And as you know, in March 2021, the insurgency took over a couple of towns around the Area 1 concession. And this led, according to press reports again, Total Energies to declare force majeure in April 2021 and withdraw its personnel from the construction site. Since then, I understand that Mozambique has enlisted the help of the Rwandan military and other militaries to try and stabilize the situation. I understand that the situation has stabilized a little bit, but still very volatile. And I understand that the Total Energies construction site is still under protection from the Rwandan military. In September last year, Total Energies CEO said that he was planning to resume constructions in 2026. But in February this year, again in the press, Total Energies CEO said that, construction would not resume until after all displaced people are back into their homes and the situation has stabilized.
I see. Thank you for this very clear explanation. And so then next question would be for probably that, what are the implications of the current situation?
Well, as you can imagine, the stakes are high there, both for Mozambique and Total Energies. Starting with Mozambique was expecting a lot of royalties from this project, and I understand that they had timed the maturity of the debts based on the timing of the project, so that they could service the debt with the royalties. So all that is now put into question, and of course, Total Energies also is in a difficult situation. We know from the information they published on their own website that this project has been financed primarily through debt, project finance, and they said to have eight loans from export credit agencies, 19 commercial bank facilities, and a loan from the African Development Bank. So they are of course keen to avoid a default under these contracts. And Total Energy has also to deal with its subcontractors, in particular its engineering, procurement, and construction contractor, which is a consortium led by Saipem. It's also a massive contract, 6 billion, and of course, they try to avoid any issue there. And of course, there are also dozens of local subcontractors. Although the press, I saw nothing in the press about that, but I assume that Total Energies has declared force majeure in all these contracts as well. If I may say some things on the concession agreement of Total Energies, which has been made available by the Mozambican Petroleum Agency's website, and I understand, this is the official version that is published in Portuguese. And it's interesting there to see that they do have a force majeure clause, as you would expect. And this clause provides as follows, and I would translate from Portuguese. It says, it defines force majeure as any cause or event outside of the reasonable control of the party that alleges having been affected by this event and not attributable to that party.
Thank you, Paco. And it's quite useful to have the concession agreement being publicly available. And on that, do you think we need to take into account also Mozambique law in relation to the force majeure? Or what are the other sort of comments you can make here?
Yes, well, the force majeure is defined in the contract, so that would per se avoid the need to rely on Mozambican statutory law, namely the civil code, which would be applicable in this case. And the force majeure clause is useful here, and the insurgency qualifies as a force majeure event without any doubt. I think it's a good thing that there's this clause in the contract, because the notion of force majeure does not exist in Mozambican law.
And is there any equivalent or concept?
There is an equivalent sort of concept in Mozambican civil law, in civil code. It's the concept of impossibility of performance. But the concept is slightly different. At least, one of the requirements for impossibility to arise is that the impossibility of performance is permanent. And this is assessed based on the interests of the obligee. To put it differently, the obliger, under this concept of impossibility, the obliger is not excused from performing if impossibility is simply temporary. And it will be deemed temporary if the obligee retains an interest in the performance of the obligation by the obliger. So if, assuming that if there was a contract there where this notion of impossibility applied, then perhaps it would be more difficult for Total Energy to excuse itself from performing, because it might be said that impossibility remains temporary because the other party would still retain an interest in the performance of its obligations by Total Energies.
Well, thank you very much, Paco. We could go on, I think, for even longer on those very interesting topics and developments in Portuguese-speaking countries in Africa. Thanks again. And I will be happy to see all you in the next episode of Arbitral Insight.
Thank you very much again, Clément, for the invitation, and I look forward to the next opportunity to participate in this podcast. Thank you very much.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email arbitralinsights@reedsmith.com. To learn about the Reed Smith Arbitration Pricing Calculator, a first-of-its-kind mobile app that forecasts the cost of arbitration around the world, search Arbitration Pricing Calculator on reedsmith.com or download for free through the Apple and Google Play app stores. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.